And I have to say, it's a troubling day when I see that your client is better behaved than you are. And so I'm going to ask again, do you need a break to pull yourself together, or can we proceed here today? All right, we are here for sentencing. Are the parties ready to proceed?
Yes, Your Honor.
Defense is not ready to proceed, Your Honor. There's some substantive errors in the report, specifically, and I will concede my memory is not the best, but Mr. McDonald was remanded into custody in this case. They're recommending 2 days credit. There should be, and I'm gonna have to check the court minutes, there should be about 500 or 600 days of credit. He was in custody in this case for actually a significant period of time, as contemporaneously with the other case pending results. So I'm gonna have to pull the court minutes and maybe even the transcripts.
And I'm sorry, if Mr. Mueller's done,
Thank you.
were there other errors?
Well, the answer is this is 10 felony convictions. In other words, one case, companion case. He doesn't have 10 felony convictions for. Strictly speaking, yes, but it makes it look like he's a 10-time felon. He's got one other case that he wanted to take to trial in the district, the Nevada Supreme Court hasn't ruled on yet. So he's not a 10-time felon.
Well, that wouldn't be my consideration. I recognize that there is one case with multiple felony convictions in that, so that wouldn't be a substantive error or a mistake in the PSI, and that wouldn't change even if we got a continuance. So that will be, I understand the underlying nature of the case you were convicted of, the number of counts, but that doesn't mean that you have 10 separate felony cases. It's one case, multiple felony convictions, all right? And so let me hear from the state regarding the other issue in terms of credit for this case.
Yes, Your Honor, and I agree with counsel that the PSI actually has the wrong number of days credit. I calculated it because the defendant's bond company surrendered his bond on October 15th of 2019, and he's been in custody since then. And so he has 146 days credit from that, and that should be added to the 2 days listed. So he should have a total of 148. He was in custody on other cases while he was not in custody on this case, and that was repeatedly stated on the record that he was not in custody on this case. So my calculation is that he has 148 days credit time served total.
All right.
And rejoinder, thanks to my colleague, I agree, there was more credit, but there's additional credit due. If memory serves, I stood up and had specifically remanded in custody on this case. So if...
when was that, Mr. Mueller? And first off, this PSI has been, was ready back on February 11th. So tell me why we're addressing this today.
we're going to just look at it today.
And
We can do the sentencing judge, you're going to set it over for the calculation of credit for time served. He was remanded in custody. My memory serves. Okay, I remember very clearly coming to the court and getting remanded and telling him specifically, saying, okay, when you do your other sentence, give me a call so we can put it back on the calendar.
Well, here's my concern, Mr. Mueller, is that there seems to often be confusion between this case and the other case.
True, it is very difficult keeping them straight, and I've had some trouble with that, and I'll concede that. But having said that, I know that he's entitled to more credit.
and Your Honor, I do have a copy of the defendant's scope that was printed off this morning.
Yes, if I can take a look at that, I appreciate it. So first off, I'm looking at a change of custody form, thank you, dated March 13th, 2019. He was OR'd. It looks like he was in custody back on January 7th of 2019. And he was not in custody as of April 15th, 2019. And then the bond surrender happened on October 17th of 2019. So if we were to do the calculations from October,
He's in custody from January to March, that's another 60-something days.
no, he was not in, well, he was in custody as of January 7th, and then at least it was following on to see he was released from his overcognizance.
As of what day?
March 13th.
So January 7th to March 15th. That's why I said, Judge, we could take docket time, or I could just schedule a day to hold it.
Why don't we actually pass this to the end of calendar so we can spend some time going through that, that way we can clarify make sure we're doing the tabulation correctly, all right?
Thank you.
Go ahead and have a seat.
Pursuant to that Supreme Court ruling, you get going to be qualified.
This is the time set for your hearing on custody.
Any statement that you make is under penalty of perjury.
No, that's not how that works.
We will take this case under submission.
That would require proof by very significant evidence.
You both did a good job bringing all this to my attention.
I'm going to make a record about you in a minute. You need to sit down and be quiet.
Main seat didn't come to order.
Let's go ahead and recall C-18-333-684-1, State of Nevada versus Michael D. McDonald. Good morning again, Mr. McDonald. Mr. Mueller is present, along with Ms. Mishler for the state, and I do see we have a victim present here in court today. Mr. Reed, you'll go last in terms of sentencing, all right? All right, so Ms. Mishler and Mr. Mueller did have my GEA printed out a copy of some minutes about him being remanded. I don't know if that provides some more clarity in terms of what his CTS is.
Yes, Judge, what I had recollected is when these charges were filed, the city used these charges in the other case to remand him into custody in municipal court for 6 months for violating the stay out of trouble on a case that was going to be dismissed. I specifically recollect walking in here, this apartment, in the Judicial Department, and having him remanded. That would have been circa somewhere around January of 19, which is, I believe.
Which is reflected in Odyssey. He was in custody on January 7th, 2019.
Okay, so it's rare that my memory gets vindicated, but at least on this occasion, my recollection seems to be correct.
Started September.
And then there was a change of custody status as to March 13th, 2019. He was released on his own recognizance in this case. the change of custody form was filed.
So that at least is from January 7th to March 19th, that's additional time we
Well,
developed.
that would be about February, March, about 65 days for that January to March 2019 time period. Do you have an objection to that, Ms. Mishler?
And the only thing is, Your Honor, I go by scope. That tends to be the most accurate
Oh, yes,
document
we should go
in
with
terms
this.
of when defendants are remanded, and I don't, and you have my only copy, I don't recall seeing a remand date for January 2019. That was how I calculated his credit, but it's,
So I see a remand in case C119281-A,
that would have been a municipal court case.
right?
And of course,
And
he was
that's-
in, yeah.
That looks like that's from September 25th of 2018, so he wouldn't have been remanded in this case. Now, if he wasn't per se remanded, if there was a bond surrender, would that still reflect on scope as a bond surrender?
Yes, I believe that's actually on there. That's where I found the October 15th date for, because I think the court shows it was October 17th, but I believe scope shows that it's October 15th, is where I calculated.
And that might be true because by the time it gets into Odyssey, it's a couple days later.
Exactly.
Well, I think though, that's correct in that he was then remanded on October 15th, 2019, but he was still technically in custody per Odyssey between January 2019 and March of 2019. Then he's out of custody and he gets remanded back in.
Okay, if that's the state's position, I actually have a date-to-date calculator on my phone.
Oh, okay, great.
So
So
if you give me the exact dates in January and March, I can
absolutely.
calculate.
I have him in custody on January 7th, 2019. And then there's a custody change on March 13th, 2019.
Is it March 13th?
Yes.
That would be an additional 65 days, so I would say his credit is then 148 days plus 65.
Which is about 213 days. Does that sound right to both
That's
sides?
about what I was expecting to see on the report, Judge.
Ms. Michelle, let me give this back to you since it's your only copy. This is the scope. Thank you very much. All right. Now that that issue has been resolved, is there anything else in the pre-sentence investigation report that needs to be changed, Mr. Mueller?
No, Your Honor, it doesn't matter, the court knows that we're doing the trial, so I'm sure you're familiar with the facts.
All right, let me turn to Mr. McDonald. Have you reviewed that pre-sentence investigation report dated February 11th, 2020?
No, I have, can I proceed? I have the old one.
You haven't taken a look at the new one?
I think he briefly showed, but I didn't get to review it.
All right, then I'm gonna take a 5-minute recess so we can take a look at that and I'll be back. I apologize for keeping you all waiting, but we need to get this taken care of. All right, so I'll be back in 2 minutes.
Being seated and come to order.
All right. Again, recalling C-18-333-684. Gonna pick up when we left off. Mr. McDonald, have you now had a chance to look at that pre-sentence investigation report?
Yes, I did, Judge. Thank you.
Anything in it that needs to be changed or brought to my attention?
You guys changed the credit through time, sir. Thank you.
That will be reflected, yes, no problem. Anything else?
Not that I can, not that I can tell, Judge.
Okay, all right, thank you. Well, then we're gonna turn to the state for sentencing. When you're ready.
Thank you, Your Honor. And today I ask that you impose a prison sentence of 14 to 36 months. I feel that the two counts should be run concurrently to each other, but I feel very strongly that the sentence in this case needs to run consecutively to his other case, C-335284. The crime in this case is distinct from his other case. It was a blatant invasion of privacy. And I won't go into a huge amount of detail about how this crime affected the defendant's ex-wife, Ms. Ruiz, because she's here to talk to you about that, and she'll certainly do a better job than I could.
And I also read her letter.
And you presided over the trial. But I do want to address it at least a little bit. She was the one who reported this case to the police, not the other case, but I don't think she fully realized when she did that what she would have to go through in the course of this criminal case. I've had this from the beginning, and I've seen how traumatic this has been for her, having to play these audio recordings for her in preparation for the preliminary hearing, in preparation for trial, then listening to them at trial and having to explain these embarrassing issues like her daughter's medical problems to strangers, to jurors, and then having to be cross-examined. She's gone through a lot in the course of this case, and it's particularly concerning the bizarre YouTube videos that the defendant posted that included these audio recordings as well as private photos and journal entries. And the defendant just refuses to accept responsibility. He has repeatedly claimed throughout that this is some sort of political prosecution and that he's being politically persecuted, that he's an enemy of the state, which could not be farther from the truth. Quite frankly, the defendant is politically insignificant. No one in the DA's office ever cared that he ran for Assembly District 20 in 2017. Anyone who can afford the filing fee can do that. And I looked it up once, his campaign raised about $200. He did get some votes, but that's likely because he happens to share the same name as a more prominent local politician. And ironically, from the beginning, he's accused Ms. Ruiz of masterminding this prosecution with her political connections, which are non-existent. She's an English teacher who's not politically connected. And the defendant even went online claiming that she was legally abusing him. And the defendant is often dismissive of his criminal history, just blaming it on his family court case and his ex-wife. But his ex-wife didn't make him file fraudulent documents to the court in his other case, or commit perjury in 2 different ways regarding where he worked so that he wouldn't have to pay child support. She didn't make him fight with marshals when they attempted to take him into custody, and she didn't make him make these recordings or post them online. And in light of all of the defendant's conduct, this may not matter much, but I would be remiss if I didn't address the defendant's claim that was in both the PSI interview and the sentencing memorandum that he's been the director of a nonprofit called Positive Minds Global since 2017. There is a local nonprofit by that name, but according to both the organization's website and the Nevada Secretary of State, the defendant is not associated with it. The director and founder is a completely different person. And the nonprofit wasn't even founded until November of 2017, and shortly thereafter, the defendant ran into a number of criminal cases. And even if that were true, that would be another type of employment he had that he didn't report in his family court case. It would be related to another inaccuracy on his financial disclosure form. The defendant just repeatedly keeps lying and blaming his actions on everyone else, and he deserves consequences. So I ask that he receive a prison sentence of 14 to 36 months to run consecutively to his case in DC 28. Thank you.
Thank you very much, Ms. Mishler. All right, Mr. McDonald, you can make a statement this morning, but you don't have to. Would you like to make a statement?
Yes, I will, Judge.
You may go ahead.
Judge Cristina Silva, I want to first apologize for this case having to come before you. And then I also want to apologize and ask for forgiveness for my ex-wife. I never meant for these private phone conversations to become public. There was a YouTube video that had some snippets, but not those full audio recordings. It was Mark Casario posed as a court reporter and said, I'm interested in the case, and gave him access. I never gave him permission to put those phone recordings on, Judge. And I really am embarrassed and ashamed that my divorce came to this point to where I'm in prison now, Judge. I apologize to my kids who I haven't seen for over 3 years now, as I've been in jail for mostly 2 years due to my emotional reactions. Judge, as you heard from the phone calls, I was very emotional through the divorce and my ex wanting to divorce me. All the emotions from my past and my parents' divorce and parental alienation, pathogenic parenting blinded me a lot, as I did not want my children to suffer and be alienated from their father as I was as a child when I was 5. Parental alienation, pathogenic parenting is the root cause of so many social issues, such as anxiety, depression, mental illness, criminal history, drug use, sex trafficking, mass shooting. As I'm sure you're aware that most of you, the cases that come before you, they didn't have their father growing up, they didn't have their mother, or they had those circumstances in the past that caused it. Judge, I had no criminal record before all this divorce. All my charges stem from this. I've done a lot of healing and a lot of reformation, a lot of classes. I've taken every class that I could take, and I've completed over 80 classes for the domestic violence situation. I never hurt my ex-judge, or I never intended to. And I want you to take into consideration that people get emotional into divorce. It's probably the worst part of a person's life. I would never wish divorce or jail or prison on anybody, Judge. And I want you to please consider that. I made a mistake. I will not commit any more crimes whatsoever. I have a new profound and understanding of the profound respect for the criminal justice system, and I had no understanding of that before. I wasn't in trouble before. I didn't understand what all these orders and everything that I just wanted to be in my children's life, Judge. I ask that I want you to know that I've healed a lot through those years, and that I also realized through counseling, which I've gone on my own. I've taken counseling. I've gone through multiple counselors and MFTs and different people to address the issues that I have from the adjustment disorder. And I want you to know that I was very codependent on the relationship, as I understood that from the correlations from my past from the divorce, and me and my ex were both children of divorce as well. Judge, I also want you to know that I'm facing 3 years in prison already, Judge. And I've done over 2 years. I've lost almost everything. I just want to move on forward with my life. I'll stay far away from my ex and do whatever the court orders me to do, and pursue that in family court when I get stabilized and able to go back to work and get my life back in order. I had good positions, Judge. I used to work for the city. I had no criminal record. I know a lot of people out here. As to Positive Minds Global, yes, I am a director. I've helped with that. I was helping establish that. I did the business plan. I've been helping to do fundraising. I wasn't getting paid for the position, but I was helping to establish that and help with the courtyard and also keep families together. I also volunteered over at the UNLV to have custody and divorce classes there, and trying to prevent this, to help people do mediation and prevent the same thing so that they don't have to go through and suffer what I've been through, Judge. I just want to ask for your grace and mercy and consideration that this will never happen again. I learned my lesson. I can't believe how emotional and dumb I was. I know the pitfalls that I fell into. And now I understand that a lot of that stemmed from my past. And I've gone through all kinds of different things, Dianetics, and different things to help and learn to help people as well, Judge. And I will no longer suffer emotionally, and I've been able to stable. I've read so many self-help books. I've probably read 1,000 books since I've been in. So I just ask for your grace and mercy, and please to give me probation and give me that chance. I've not been given any probation or any chance throughout these whole court cases. I've been maxed out. And I ask to show this court that I can follow any orders and all the other orders too. I know now. Oh, man, I never thought I'd end up in prison, Judge, or suffer this amount of time. So please, Judge, take that in consideration, and please give me the leniency, and I ask for your mercy. And again, I apologize for all this and for the emotional turmoil I've caused my ex and everybody else in this matter. Thank you.
Thank you very much. Mr. Mueller.
Your Honor, I wish I had kept a log about how many jury trials I've done. With the exception of 2 court-martials I did at the Air Force Base, I was always very proud that every time we finished a trial, I was pretty well convinced, win, lose, or draw, that the truth had come out. And that's one of the high points of practice in criminal law. This case is very concerning to me because I'm not convinced the truth has come out. This is the first time I've walked away from a jury trial like this in state court. I don't understand at least 7 or 8 key points. I don't understand if 50 or 100,000 divorce cases get filed down there every year, why this particular one was singled out. I've had 3 or 4 senior family court lawyers come up and laugh. Said everyone in court's everyone down that. That this is, they don't understand how this case even made it here. Number 3, why or how come a family court judge confronted with a violation of a court order doesn't enforce the court's old order? If I did something inappropriate in front of you, you've got contempt powers over me, and just as you will with my colleague. Number 4, I'm very uncomfortable that we have a legal system so complex that a pro per person walked into it and ended up in prison. I want that to sink in for a moment. Doesn't have money for a lawyer, he's gotta go get divorced, and ends up in prison.
Well, Mr. Mueller, that's really simplifying other things that intervene acts to include acts of domestic violence and other things.
My
So
colleagues
let's be
sought-
mindful of that argument.
My colleagues sought, on behalf of the state of Nevada, to intervene in a divorce case. I actually had to go down and defend that in front of Judge Henderson. I've never heard of it. It's extraordinary. And I keep pointing out these extraordinary things. This doesn't make any sense. This doesn't make any sense. This doesn't make any sense. And here we are standing on whether he's gonna go to prison for reporting his wife or for Mark DeCiro downloading a clip from his page. I don't understand it. So respectfully, Judge, he's got some emotional issues, he readily concedes that. He's got no history of violence until his divorce hit him hard. He was doing okay in the community, keeping a job, supporting his family. I don't see any compelling reason to put this man in prison. And my colleague, who's never been to family court and never handled a divorce case, seems to be convinced that that's what needs to happen. And respectfully, I think she needs to go down and watch a few divorce cases. I concluded very early in my career that I couldn't do that and practice criminal law because everyone down there just lies. Everything in family court is a lie. I've never seen anything like it. Now, she's standing up here demanding prison time. I'm sitting here defending an unprecedented charge. I've never seen this before in 30 years. Or for that matter, even talk to anybody who's seen this. So I respectfully ask the court to give him probation. I think he'd be a great probationer. Order him to continue in his counseling, and I submit it, Judge.
Thank you very much. Ms. Louise, when you're ready, come on up, we're going to swear you in, and then we can finish what you say.
You do solemnly swear the testimony you're about to give in this section shall be the truth, the whole truth, nothing but the truth so help you God.
I do.
Please state your name for the record.
My name is Candace Ruiz.
When you're ready.
Before I begin my statement, I just wanted to thank the court for hearing this case, and specifically Ms. Mishler. I felt really cared for during this time. I felt understood, and so I wanted to thank her. And then also my friends and family who have stood by me throughout this process. I truly believe I couldn't stand here before you today without their support. Your Honor, in order to understand the impact that the crimes that Michael Lee McDonald committed against me between August 1st, 2016 and November 30th, 2016, you must understand what has happened to me prior to these crimes. On the surface, these crimes may seem minor. However, it is my hope that once you understand what I have survived, I'm sorry, I'm a
It's
little
okay,
nervous.
if you need to take a breath, and there's tissue there, you can do that, no problem.
You will know that Michael's crimes were an act of domestic violence, meant to silence me. They were calculated and meant as a means to control and manipulate me as well as the family courts. Over the past 5 years, I've had to protect myself and our children from Michael's erratic and violent behavior. While Michael would like you to believe that the charges brought against him were unfair or done unknowingly on his behalf, this is simply not the case. Michael knowingly recorded very private phone calls between him and me and shared those recordings with strangers, as well as posted them to YouTube. In those YouTube videos, Michael included not only the phone calls, but also pictures of me in a bra and panties, pictures of our children, private text messages, cards and letters I had written to him. and photos of my most private journal entries. The phone calls and other items posted were intimate and shared without my consent. These phone calls were not an isolated incident. Michael also posted our entire divorce on YouTube for strangers to view. Because of these videos, Michael has subjected our children, myself, and himself to the scrutiny of the entire world. I frequently receive messages on Facebook from people around the world who have viewed these videos and reach out to me with their concerns for my life and that of my family's. The content of these phone calls contained very private information about our daughter's serious medical condition, her diet and medical needs, our divorce, the physical, sexual, and mental abuse I suffered in our marriage, details about my personal dating life, and difficult and painful struggles that Michael and I faced in our marriage. In the phone calls, Michael also accused my boyfriend, now husband, of molesting our 2-year-old daughter. He tried repeatedly to get me to admit that our daughter's rectal prolapse was due to sexual abuse, even though doctors, Child Protective Services, and police had told him otherwise. When I did not agree with him, he then accused my brothers of molesting our daughter. Michael intended to use these phone calls to pursue sole custody in the family court. He knew that if there was an allegation with proof that he had created, or if he could get me to admit abuse that he made up, he could obtain sole custody. I am still unable to decide if Michael truly believes these delusions, or if he simply wanted to obtain sole custody for the purposes of not paying child support. Either way, this tactic was low and extremely concerning to me. It certainly was not what was in the best interest of our children. When Michael could not obtain custody through false sexual abuse allegations, he decided to defraud the court by forging a letter and passing it off as if his counselor wrote it. This letter was also a means to obtain custody. Ultimately, Michael was caught for his crime and convicted of forgery and burglary. He also lied on the witness stand during an evidentiary hearing, stating that he did not have a job in order to get out of a larger child support obligation. He was charged and convicted for perjury as well. Michael is not a man who cares for his children, and his actions have proven that time and time again. Aside from the phone calls, Michael attempted to abduct our children on multiple occasions, attempted to use fake and forged documents to aid him in his quest. When Michael was not incarcerated, he tried to abduct our children from school, after-school safekeep, daycare, as well as our church. These attempted abductions resulted in 2 convictions of an extended protective order. Michael was also convicted of domestic violence for pushing me, an incident which is still traumatizing to our children. Unfortunately, because of Michael's poor choices and lack of ability to control himself, our children have been subjected to violence, resulting in interactions with the police and Child Protective Services. Our children have suffered unnecessarily because of the danger that he is to them. Not only is Michael a danger to our children and myself, but he is also a danger to others. On 2 separate occasions, Michael resisted arrest, one of which he was convicted for and the other of which he was never prosecuted. During one incident, Michael, with his sheer strength, picked up 2 bailiffs on his back while trying to resist handcuffs. Also, on multiple occasions, Michael has stalked and harassed my friends and family. His relentless nature is exhausting, stressful, and terrifying. Many of my friends and family are fearful that Michael will harm them personally because they care for me. I continually have to plan for protective measures for myself and our children while Michael is out of custody due to his inability to stay away from us. He is obsessive and he views our children and me as his possessions, stating that he has God-given rights to us. Michael went as far as to breaking into my car, installing a GPS tracker, and showing our son on an iPad how he could follow me. Throughout the duration of our marriage, Michael was extremely violent, controlling, and possessive. There were many domestic violence incidences that resulted in Michael pushing me, pulling my hair, choking me, and taking my car, keys, and cell phone so I could not get away or call for help. Michael was physically, emotionally, and sexually violent with me. He frequently locked me in rooms, prevented me from seeking medical care for our children when it was dire, and he threatened my life. Michael would also use gaslighting techniques to control and silence me. The fear that I felt from Michael was crippling, and it prevented me from reporting these crimes or advocating for myself. I was constantly paralyzed with fear. Michael is still unable to admit any wrongdoing or show remorse. Michael is dangerous and will stop at nothing to harass, stalk me, or even coerce other people into helping him commit the above-mentioned behaviors. These people include his family members and friends that he met while incarcerated. In fact, Michael's family enrolled Michael's younger brother on a zone variance at the high school that I teach at. Michael has a history of mental illness in his family, including bipolar and schizophrenia. Michael was diagnosed in his early 20s with bipolar mania disorder, and over the years has refused to address the severe mental health issue or medicate, despite repeated negative consequences. Mental health treatment has been offered to him on several occasions. Michael was ordered on multiple occasions by the family courts to get mental health treatment. He was offered mental health court in this case as well as the other, but Michael has refused to take the help that he desperately needs. I have come to understand that Michael does not want help. He does not think he needs it. He believes that he is above the law and that the rules do not apply to him. Since my separation from Michael, our children and I have attended long-term counseling to cope with the stress and anxiety that has been inflicted upon us. While we have learned to cope, we still have nightmares, hypervigilance, and anxiety. We suffer when Michael is out of jail. Finding my voice and learning to advocate for myself and my children has cost me in many ways. It has consumed my time and energy. I have missed so many days away from my career that I love to attend court dates or advocate for myself and our children. I do not receive child support, money I'm happy to live without for the safety and security of myself and my family. Although I have spent money on lawyers' fees, therapy, childcare, home security, and protection for myself, I ask nothing monetarily. There is no amount of money that I would spend becoming mentally strong and to be free from Michael's control and abuse. Michael's crimes against myself and our children have increased in frequency and intensity. I fear that the consequences for Michael's freedom could result in my death or the deaths of our entire family.
Mr. Mueller, do we need to take a time out so you can control yourself? Because you're going to give Ms. Ruiz, as I would ask any person to give any victim, the respect they deserve.
Yes, Judge.
Do you need a break?
No.
You may continue.
Michael McDonald is not a man who made a mistake. The crimes he committed were calculated and meant to cause harm to me and our children. The recorded phone calls were only another tool for Michael to control me and manipulate the family court. There have been many crimes that Michael committed that were either overlooked, required more evidence, or went unreported for the fear of the loss of my life or the lives of those that I love. Today I stand before you, whole, healed, and free. I have finally found my voice, and I ask that you hear my plea. I implore you to give the heaviest sentence. It is truly the only way that our children, the community, and I will be safe.
Thank you very much. Mr. Mueller, I'm not quite sure why it's necessary to kick the desk or to give me, I would call them glares, please do not interrupt me. I'm troubled by your behavior today, and I expect professionalism of everyone who comes into my courtroom. And I have to say, it's a troubling day when I see that your client is better behaved than you are. And so I'm going to ask again, do you need a break to pull yourself together, or can we proceed here today?
I'm ready to proceed, and I wasn't kicking the desk. My table chair was caught in the middle on the floor.
And for the record, while Mr. Mueller has engaged in unprofessional behavior, that will not impact my sentencing determination here today. You've always been professional in front of me, and I appreciate that.
Thank you.
In accordance with the laws of the state of Nevada, I hereby adjudge you guilty of 2 counts of unlawful interception of wire communication, which is a Category D felony in violation of NRS 200.620 and 200.690. That carries a potential 1 to 4 year term in the Nevada Department of Corrections and up to a $5,000 fine, or both, and that's as to both counts. Those counts are in relation to counts 2 and 5 that the jury returned a guilty verdict on. I'm going to order that you pay a $25 administrative assessment fee, that's standard in every criminal case, and a $3 DNA assessment fee. I believe your DNA has already been taken, so there shouldn't be another fee associated with that, but I will note for the record, if that has not been paid, there is a $150 DNA collection fee or submit to testing for your DNA, but that will be waived if it's already been paid. I will then turn to sentencing, and I will note that I did review the victim impact statements, the sentence memorandum. I heard the statements of Mr. McDonald, the arguments of both counsel, and the statements of Ms. Ruiz. I also am mindful of the evidence that was introduced during the course of this trial. I also thoroughly reviewed the pre-sentence investigation report. And I want to talk about what I consider when it comes to sentencing, so you understand where I come from. I always take a look at a number of factors when doing sentencing, everything from the nature and circumstances of the underlying offense to the history and characteristics of the defendant and the offender, the need for a sentence to reflect the seriousness of the offense, to promote respect for the law, and to provide for just punishment. I also consider making sure a sentence affords adequate deterrence from future criminal conduct, to protect the public from crimes of the defendant as well as the victim, and to provide a manner in which potentially the defendant could get some kind of training or treatment. I'm also very mindful of what could happen if I were to impose a sentence that would result in a disparity, meaning a person who is similarly situated as you ended up, you ended up with a greater sentence, or they did, or vice versa. But in taking that into consideration, I have to evaluate the fact that not every case looks the same, and not every case is carbon copy. And while somebody might not have that much criminal history, when you kind of dive deep into the facts and circumstances of a particular case or particular offender, there might be more there than what appears on black and white paper. And that's really where I land with you. I do give you credit for the fact that you have limited criminal history. It's very clear to me that your inability to conform with the laws and with societal obligations stems from the divorce. That doesn't make it okay. People go through divorces all day, every day, in this city and cities across the country, and they don't engage in the behavior that you engaged in. I think that a lot of your behavior and your actions were driven by your mental health issues that you denied that you had, or at least failed to admit that you had, or perhaps you knew that you had them but you refused to treat them. I don't know what the combination of, or maybe it's a combination of all of that. As you stand before me today, I do believe that you are starting to acknowledge that you do have mental health issues. I do believe that you have stepped down from your prior position of denying all wrongdoing. My question is, why have we had that shift? And perhaps it's because you have become a little bit more stabilized in custody. Or perhaps it's because you realize that, the jig is up, you've been convicted, not only in this case, but in another case. Perhaps it's a manipulation technique, and I don't mean that to be offensive, I mean that as people are human and they try and survive, and so they are going to manipulate their behavior in order to engage in those survival techniques. That's not a disparaging remark against you, that's just human nature. I think, candidly, it's a combination of all of those things. I think that for a long time you were in denial and thought you could engage in whatever behavior you need to engage in to get custody of your kids. I appreciate that you love your children, but that is an unhealthy way to show your love, and a dangerous way to show your love. So, so here I am, trying to figure out how to sentence you in a way that properly reflects the crippling effect, as it was said, of your decisions, right? The crippling impact on the physical impact it's had on your family and on you, the mental impact it's had on your family and on you, the emotional impact it's had on your family and on you. And it is very concerning to me, and I give a lot of credence to the fear that your wife expresses. I'm confident as you stand there in that box, you think, I would never do anything and I would never act out that way. And I see you shaking your head in agreement with me. People say that to me all the time, and I think that when they say that, they genuinely mean it. But there's a difference between being able to follow through with that and saying it, right? Because it's easier to say that when you're standing where you are than going out into the real world and figuring out how to function as an adult and not to engage in the same behavior. Do you understand what I'm saying?
Yes, Judge, and I hope that the record reflects that when I was out on ankle monitoring, and then when ankle monitors took, I've gone nowhere near her, nor did I pursue anything, only through family court, and have done no other reoccurrences as a pregnancy.
So, and I appreciate that, and I'll take note of that, but here's what I'll also say, that you utilize the family court to do and act in a way that was unreasonable and reflective of somebody who has mental health concerns and mental health issues. That's not lost on me. I think it's a real tragedy that you were unable, for whatever reason, to accept responsibility early enough to get the treatment that was offered to you, that mental health court was offered to you, and it was turned down. I took over this case in April of last year, and I can recall at least 1 or 2 hearings on mental health court and probation was an offer, and if I recall correctly, that was an offer on the day of trial, just at the start of the October trial, if I recall correctly. I think there was or maybe no argument. There was something that was wouldn't have resulted in custodial time, and that was rejected. And we went to trial, but ultimately this trial, and we went to trial again in January, and we were convicted of 2 counts. So the state has asked me for a 14 to 36 month sentence concurrent between counts 2 and 5. The victim has asked me for a maximum sentence, and to be clear, that would be a 19 to 48 month sentence, and that would be consecutive. And if I were to impose the maximum, that would be consecutive to your other conviction. And what I see that you have received, and Ms. Mishler, correct me if I'm wrong, in Judge Israel's case, he was sentenced to an aggregate sentence of 24 to 68 months in the Nevada Department of Corrections. Is that correct?
Yes, that's correct.
All right, with 215 days of credit for time served.
Yes.
All right. So taking into account all of the facts and information that I have before me, and the factors that I have indicated that I consider when I impose a sentence, I am going to impose a 14 to 30 month sentence. I am going to have those run concurrent, but I am going to have it run consecutive to Judge Israel's case, and that is case number C18-335-284-1. Again, I think that it is appropriate, given all the information I have before me. I also would like the judgment of conviction to reflect that I recommend Mr. McDonald receive any mental health treatment that is available while he is in custody. I don't know what is available, but I do make that recommendation. Mr. McDonald, I wish you the best of luck, and I really do hope that when you come out on the other end that you can refocus your life and live a fuller, more healthy life than you were engaged in for many years that led you here today.
Judge, can I say one thing?
You may.
I just want you to please consider too that I asked that you run the chart at time concurrent. I've done almost over 24 months already in city jail, Judge. I've had plenty of time to go through all this. I now have at least two more years. And please, Judge, I'm gonna pursue any classes and everything I can do to take. And I just ask that I be given a chance on probation or to even run it concurrent. I swear I will not ever come back to this court. I'm gonna stay far away from my ex and do whatever I can. It's gonna take me probably a year to get back on my feet and get back to life and get back to working and play. Judge, there's so much in this case that wasn't even brought up at trial, and things that you didn't even get to see, all the different wiretapping that I did 6 months for a phone recording that she wiretapped me, and all these other things that she broke in the house as soon as I got thrown in jail, stole everything out of my safe. We were officially divorced, wasn't even allowed. Sold the house, $40,000 in market value. I lost over $250,000, Judge. It's gonna take me a long time to recover.
It is gonna take you a long time to recover.
And you know what, I appreciate you considering everything and that I appreciate everything that you've said and done. And I also, if there's any way I will pursue outpatient, or I have a psychiatrist that I go to now, and Dr. Clausino, and he's been doing the mental evals and seeing me even in jail too.
Mm-hmm.
So I just please ask that I do get that time concurrent. This 2 years is it's gonna be, like I said, it's gonna be over 4 years just in that amount of time, Judge. And I've had a lot of time to heal and reflect and ponder, and I know I've made a lot of mistakes, and I just asked for a chance to be able to see it not maxed out again, Judge. I've been given no mercy.
So to be clear, you haven't been maxed out, and I appreciate that, and let me tell you, I absolutely understand why you're making the request that you're making. A couple of things. First off, as you reminded me that I do need to give you credit for time served, so I'm gonna give you 213 days of credit for time served in this case, all right? 2, you haven't been maxed out. As I indicated, if I were to have maxed you out in this case, it would be 19 to 48, followed by another 19 to 48, and then those 2 would be consecutive to the sentence that you already got in Judge Israel, okay? So again, I understand that's how you're feeling, and that's an emotional reaction, completely justified. But like I said, I talked about all of the things that I have to consider, and
one more thing too, Judge, there is a disparity. Like, how many people have been sentenced for wiretapping before, and it is federal law, you can record, so I had no clue it was recorded. I was in California, most of the calls, or all of them did. And I apologize to this court. I can't believe, I wish I would have been able to just take the deal and have a resolution. It was a wobbler probation. And I would have gone, I have a whole newfound respect for the criminal justice system. Before, I didn't know that you can get thrown in jail for almost anything, and to have that.
Well, it's not almost anything. There does have to be a minimum probable cause that a crime has been committed and you're the individual who's committed that crime.
Judge,
again, and I understand as you stand here today, why you have that position. But we are where we are, and that's just another collateral consequence of the decisions that you made. You're not going to change my mind, okay?
Right,
and again, I appreciate you. Like I said, you've always been professional in front of me, and I really do appreciate that. So it gives me hope that perhaps you'll get the treatment that you need, and you can have a better future going forward.
I will, Judge. Thank you.
You take care of yourself.
All right.
Thank you.
Thank you, Judge.
Anything else we need to address?
One thing, Your Honor, I may have misheard you. I thought I heard you say the sentence was 14 to 30.
No, it's 36.
Okay.
Is what you asked for. 14 to 36, concurrent as to count 2 and 5, but consecutive as to KC 3.
335 to 84.
Thank you very much. Yes, that's the one.
Thank you, Your Honor.
Right, thank you. 213. 213, yes.
I would anticipate noting an appeal on this matter before the, getting back to the office today. I'd ask for the court to order that for finding of Mr. McDonald's indigency, and so I make the transfer favorable.
I will make that finding now, and if you need the transfer, you'll have to apply for it. Mr. Mueller, FYI, Department 5 needs you back, so if you could head to Department 5.
Yes, I
Okay.
made the mistake of letting Mr. Maynard have a day off, and I'm now paying for it, brother.
All right.
Thank you for
Thank you.
Just a quick second.
Thank you, Your Honor. Thank you. We are in recess.